Hello everyone and welcome back. In this video I'm going to talk to you about the Baker Act and involuntary detention versus voluntary. And if you have seen any of my other videos, you will know I've talked about the fact that there are two types of Baker Act in Florida. There's the involuntary detention or involuntary Baker Act and the voluntary Baker Act, meaning that you've actually agreed to be Baker Acted. Well, why would you ever do that? Well, a lot of the time people are getting either tricked into agreeing to be there voluntarily, because you're supposed to give informed consent when you agree to be voluntary. The idea being you understand and know the consequences of what you've just done by putting your John Hancock on this piece of paper, or somehow you get coerced into doing it. You know, if you don't sign this document, you're never getting out of here. If you don't sign this document, we're going to go and see a judge in the morning, and I'm going to get a court order to keep you for the next month or 2 months. All kinds of crazy stuff. So the question is, and sometimes this is sort of part of our intake process, is how do you know? How do you know if someone is involuntary, which is what starts the 72-hour clock from ticking? And you've probably read about the 72-hour clock or watched one of my videos. So you know with an involuntary detention, the initial period is 72 hours for the detention. If you're voluntary, there's no clock ticking. You can be held indefinitely without a court order. They could just hold you, right? And remember, nobody knows you're there, so they don't care. But how do you know if your loved one is involuntary versus voluntary? Well, sometimes we can figure that out. Not always, but most of the time. Well, were they asked to sign something when they went in there? Quite possibly they signed a voluntary admission agreement. Have you been asked? Have you, as the family members, been asked to agree to anything, right? You could even agree to it over the phone. I don't think it's particularly kosher that way, and I don't see how you could give informed consent for somebody else, but I've seen it happen. Or the facility has said to you or your loved one, well, if you want them to be released, they have to sign an RTR, right to release. Well, if you're involuntary, you don't have to sign anything, okay? At the end of 72 hours, one of three things must happen if they follow the law. And you know they don't always follow the law. And you can't sue them for this, so they really don't care. Number one, they let you go. Number two, they file a petition for extended detention, which means there's going to be a hearing within 5 days. Or number three, they get you to give informed consent to stay on a voluntary basis. That's what is supposed to happen after 72 hours. But if you are voluntary, as I said, there's no clock ticking, okay? And while they are free to open the door and let you go, if you decide that you don't want to be there anymore, they are going to say to you, we need you to sign this document, RTR, right to release. And when you sign it, within 24 hours, one of two things is going to happen. Either number one, they're going to open up the doors and let you leave. Great, you're out. Or number two, they're going to file that petition for placement that I talked about. And again, that's going to require a hearing in front of a judge. That hearing is going to take place sometime in the next 5 days once they file. And so it is sometimes possible to know if the person's involuntary or voluntary. Why does that matter? Well, from our perspective, it's going to change the kind of argument that we might make to the court, right? If you're voluntary, well, what difference does it make if you met criteria? You agreed to be there. Now, whether or not you were coerced or threatened, I mean, that's, again, something to talk to the court about, right, and argue. But if you're voluntary, they don't care if you met criteria, you agreed to be there. If you're involuntary, then you need to meet criteria. And so it's important for us to decide or do the best we can to figure out what's going on. But at the end of the day, whether you're involuntary or voluntary, as I have said in almost pretty much every video I've ever put out there about the Baker Act, that if you have been Baker Acted, if your loved one is being detained, the time to fight to get out is right now, as soon as it happens. Don't wait. Don't wait. Bad things happen in Baker Act facilities. I've never seen anybody, with the rare exception, get better in a Baker Act facility unless they truly met Baker Act criteria, unless they truly needed that higher level of treatment or assessment or stabilization. And if they do, that's what the Baker Act is specifically designed for, okay? It's not designed as a windfall for these private facilities to milk your health insurance. If you absolutely should be there, great, you're in the right place, provided you're in a facility that actually takes care of the patients. And sometimes there are facilities that do it right and that do take care of patients. But the cases that come to us are where people do not get treated right, where they didn't meet criteria, and they wanted to get home. They wanted to go out of the facility and they couldn't get out. Why? Well, because this is a state statute and the state has now taken custody of you. You are a ward of the state and the doors are locked and they can keep you for as long as they want because nobody knows you're there and you cannot sue them for this. So you got to get out, got to fight to get out as soon as you possibly can. And with that said, I appreciate you tuning in. I would love a thumbs up. And if you could subscribe to the channel, I'd be most grateful. I will see you in the next video. Bye-bye.